Well, good afternoon, everybody. Thanks so much for joining us. Happy Thursday. I can see the weekend coming, and I hope you have fun plans scheduled for you. Today, we're going to talk a little bit about subpoenas, depositions, witnesses, getting folks down to trial and at deposition to have their testimony taken. But let's talk about having witness statements and having them ordered to be disclosed. When do we end up disclosing statements, witness statements, when they are ordered disclosed? It's an easy question, but it's very unclear. Sometimes the deposition is actually held hostage by applicant's counsel. We've got some situations in which applicant's attorney has refused to have the deposition go forward until the defense attorney have provided various documents, investigative reports, witness statements. Now, in civil law, this would clearly be improper and would result in sanctions. That's not debatable. In workers' comp, of course, it's the gray area. We have a case, the Vallejo case, that was relevant here. It was found that the applicant was entitled to their own recorded statements before their deposition could proceed. Now, the Armando case, it was held that the injured worker may require production of documents, including their statements, before the deposition. But compare this to the Denton case, in which is held the employer was not required to produce witness statements until after the injured worker's deposition. In short, we have completely contrary panel decisions. So whatever opinion you're going for, what other argument you're making, you will find authority going either way. I think this question is not so much what the rule is, but who can make the better argument. Let's go back to the Armando. The fact pattern is as such. The injured worker filed a petition to compel the production of witness statements, private investigator observations, which were written, and examiner notes. The employer said, no, we're not going to provide that until after the deposition. The deposition was postponed per the judge until the documents were produced. And the other documents weren't required to be produced initially. It was required that they be provided to the judge so he could determine whether there were any privileges that would prevent the documents being provided to the applicant. In our Denton case, the injured worker delayed the deposition until witness statements could be produced. It was held in this case, to the contrary, applicant was to give the deposition and the witness statements would be produced 10 days after the signed DEPO or signature was waived. So you can see we have quite a number of different ways that or tacks that the courts have taken on these things. Now, the Denton language is kind of interesting. The WCJ has the discretion to make such orders as will result in substantial justice in an unencumbered and expensive, expeditious way. I don't think that language tells us anything other than the judge can decide which way he or she wants to go and then claim it's the most unencumbered, inexpensive, and expeditious way. The timing of production of the requested witness statements is best left to the judge to determine based upon the need to encourage parties to investigate both the good and bad aspects of their positions. I would think that would fall in favor of having the applicant refuse the documents until the deposition is taken to catch naughty patterns of lying. To prevent the party from taking advantage of the industry of the other, I think this too works in the favor of the defense, and the need to prevent undue prejudice, which will result in injustice. I think they might mean by that that they want the applicant to have the witness statements or their own statement, so we can't play surprise or gotcha at the deposition. So both of these quotes really cut both ways. Let's take a look at the Brum case. Fact pattern: the California Highway Patrol death was blamed on drugs that he was taking for work stress. The defense obtained some statements from the supervisor, from the captain, from co-employees, from family members. And the statements were demanded prior to the deposition, and the witness refused to have the deposition go forward until these statements were provided. And so the question becomes, which comes first, provision of the documents or the deposition? This is more interesting and a happy ending for the defense. It was decided that the deposition goes first because the widow's truthfulness about her dead husband did not depend on her review of the statements. Arguments for the disclosure of pre-deposition failed to show significant prejudice or irreparable harm. Compare and contrast that, however, to the Kramer case. If you're starting to get tired of these conflicting cases, I apologize. This is just what the WCAB has done to us. The employer was required to produce the injured worker's own statements prior to the deposition, quote, while providing statements of other witness to a deponent in advance of the deposition can have the potential to confuse or unduly influence a deponent. Those risks do not appear as significant as when the deponent is merely reviewing his or her own statement. In fact, allowing the applicant to review his statements obtained more contemporaneous with the injury would actually aid the parties in finding fact because his memory would be refreshed. Now, I think that's a completely questionable statement because the refreshment of the memory could take place at the deposition itself when the applicant makes a misstatement or makes a misrepresentation, and then the defense could provide a copy of the statement for him or her to review and say, now, does that refresh your memory? That would not only allow for the refreshing of the memory that the WCAB seems interested in here, but it could also allow for the catching of any consistencies and the determination as to whether the applicant is going to be straightforward. What are the costs of taking an applicant's deposition? Well, all reasonable costs of transportation, meals and lodging if that's necessary, local mileage, obviously, at whatever rate is being deemed appropriate each year by the state. And if they're too impaired to drive, transportation costs. Too far to drive, planes, trains, and automobiles. John Candy was great in that movie. I think we can all agree to that. And if you remember that movie, you're probably getting a little bit up there in age. Reimbursement for missed wages. Of course, if they're temporarily disabled, they just continue to receive their temporary disability. But if they're not receiving TD and are working, they receive reimbursement for those missed wages. Obviously, they receive a copy of the transcript. Their attorney receives, quote unquote, reasonable attorney fees, whatever those are, and that's something that'll be definitely potentially up for dispute, and interpreter's fees as is necessary. Now, what about mileage? When does mileage have to be paid? Well, in the Abdu case, I love this, doing business as the Alley Dog and Burger Place, or Romo, the employer failed to provide transportation costs, and the applicant, as a result, refused to have their deposition taken until the transportation costs were paid. The trial proceeded, and it was held, and the defendant said, well, wait a minute, we didn't get an opportunity to take the applicant's deposition. We've been denied due process. This matter shouldn't go to trial. And it was held, no, you had the opportunity to take the deposition. All you had to do was provide the transportation costs, which is required by statute, and therefore you waived your right to take the deposition. Let's go for the hypothetical. Applicant misses the notice deposition and then misses the next deposition. Oh, and maybe misses the next deposition. What is the defense to do? Well, they obtain an order compelling from the judge. For good measure, the order includes, and I've done this many, many times, at least in the past, a threat to suspend proceedings and or bar benefits if the applicant doesn't appear and participate in the newly scheduled deposition. Applicant fails to appear at this now scheduled deposition that they've been ordered to appear at. What happens now? Do we suspend the proceedings? Do we bar the benefits? After all, the order included the threat to do so if they fail to appear, and they fail to appear. Answer is nope, we don't get either one of those options. Suspend proceedings and bar benefits. The judge can compel the applicant to the deposition, but they can't suspend the proceedings and bar benefits for failure to attend a DEPO. Now, it's a DEPO only, and I'm going to explain why I'm referring to a DEPO only in a couple of seconds. Contrast this to the failure to attend a medical appointment. Well, then we can suspend and bar. So as long as the employee, after written request of the employer, fails or refuses to submit to a medical examination, their rights to begin or maintain proceedings may be suspended. Continuing, if the employee fails to submit to an examination after being told to do so, their right to disability payments may be barred. So we have a lot more tools when it comes to compelling medical legals than we do when it comes to compelling depositions. However, all is not lost. We do have remedies when we get an order compelling attendance at a deposition and they fail to appear. First is contempt. You can fine them for up to $1,000, and believe it or not, in prison up to 5 days. I've never seen that, but it's a pretty big hammer to threaten, as well as reasonable attorney's fees and costs. Not only that, we can obtain sanctions, any reasonable expenses, including attorney's costs, and an order may be provided to provide additional sanctions of up to $2,500 to the general fund. Now, I have seen that, particularly when applicants' counsel is behavior is quite egregious. And what about having the employer representative at the deposition? CAW, our friends at the California Applicants Attorneys, hate employer representatives at the deposition. Why? Well, privacy concerns. They don't really want the applicant's dirt being presented to the employer directly. It can be embarrassing for the applicant to reveal deep, dark secrets. Can you imagine a psychiatric deposition, for example, and having to and have, as the opponent, having to reveal all sorts of deep, dark secrets from home in front of your employer. And our friends at CAW will also point out Labor Code 3762C, an insured third-party administrator attained by the self-insured employer, and those employees and agents specified by the self-insured employer to administer the employer's workers' compensation claims are prohibited from disclosing or causing to be disclosed to the employer any medical information. And this is one of those statutes that causes a lot of confusion as to what can and what cannot be provided to the employer. The WCAB says to the applicant's attorney and our friends at CAW, tough luck. Those three arguments, privacy concerns, embarrassment, and Labor Code 3762 aren't enough to keep the employer representative from attending the deposition. For example, this is exemplified in the Padilla case. Applicant objected to the presence of the applicant's manager, and particularly objected to questions regarding medical history and condition in front of the applicant's manager. Nevertheless, it was held by the court that the employer has a right to be present. Unless the applicant shows good cause for a protective order, and in this case, the applicant's attorney did not seek a protective order, and it doesn't appear had any basis for a protective order because the employer representative was simply going to sit there and listen. By the way, why do we want an employer representative at the deposition? For a whole host of things, but one of the best is to make sure we keep the applicant honest. And second is to make sure that he's, in addition to telling the truth about what happens down at the office, also making sure that the defense attorney can be fed questions that are relevant that he or she might not otherwise know without the manager or other employer representative whispering in their ear at the deposition. So the reasons in this Padilla case that it was held that the employer has a right to be present unless there's a showing of good cause are thus: the applicant waived the right to medical privacy for injuries at issue. Remember that Labor Code Section 3762 that said the employer can't be provided medical information by the insurer or TPA? Well, that doesn't matter because the TPA or insurer is not providing that information to the employer. It's the applicant who's providing it to the employer at the deposition. But I feel intimidated since the applicant. I'm scared of my employer. I don't want them at the deposition because they make me nervous. Well, tough luck. Being nervous, being scared, being intimidated is not a sufficient reason to keep the employer representative from attending the deposition. In your case, it was made clear the party has the right to be present, and the applicant in that case failed to identify any privacy right that might potentially be impacted. So and the claim that I feel intimidated doesn't do the trick. Why doesn't it do the trick? Well, feeling intimidated is part and parcel with workers' compensation or any other civil or criminal matter. But there are additionally there are tools to protect the applicant, even if he or she feels that they're being intimidated. First, there's applicant's attorney there. There's knight in shining armor who's there to protect the applicant from anything untoward. Second, there are legal remedies to address inappropriate defense tactics. There can be motions to protect the applicant. But he'll drive me crazier. Well, this is a different situation. In the Ferrari case, we had a different fact pattern. There was a site claim, but it was allegedly caused by the applicant's supervisor, and it was the supervisor who wanted to appear at the deposition. Well, this is a completely different type of scenario, I think. Not surprisingly, the applicant claimed that they'd become stressed. And it was held that in that situation, the employer's attendance could be barred. Because this would, as provided by applicant's evidence, cause undue oppression. The proof, well, the defense didn't provide any defense. Like, they simply accepted the applicant's statement that she had, quote, uncontrollable crying, shaking, and severe distress when confronted by the supervisor. That doesn't leave the defense with nothing to there are no options to keep the applicant honest or to allow for the defense attorney to have questions whispered into their ear during the deposition. It was stated that a different employer representative can attend the deposition and provide those additional benefits. Doctor, how many autopsies have you performed on dead people? Dun-dun-dun. All my autopsies are performed on dead people. By the way, that's from a real transcript. Makes you kind of wonder what goes on in your deposition and how it may be that you should read those transcripts a little more carefully. Service of witness statements before the deposition, after the deposition. And so we suggested earlier, it's not clear, but clarity can be found in terms of the mandatory settlement conference, because as we all know, all evidence, okay, 99% of evidence must be disclosed by then. Let's take a look at the Thomas case. If the employer improperly fails to supply the witness statement before trial, the witness may be denied the opportunity to testify. That may make all the difference in deciding whether we win or lose the case. So the witness statement before the MSC or at the MSC is the minimum time that it must be served on the opposition. What about the Christensen case? It was held that the witness testimony could not be excluded for failure to serve if the applicant was unable to prove witness statements existed. Applicant wants to strike the witness testimony because they say the employer failed, or the defense failed to provide the witness statement. Well, how do you prove that something you don't have actually exists? How do you prove a negative? Well, it's an interesting question. I think we've got the answer, however. In this situation, we would have to allow the witness to testify on direct, give out all the information that the defense wants to present, and then have applicant's counsel cross-ex the witness and ask if his or her written statement was taken. Now, this will do the trick for applicant's counsel if they can prove the statement has been already taken. but it's kind of the horse is already out of the barn because the judge has already heard the witness's testimony. He or she is supposed to completely ignore the testimony that they've heard from that witness who's now been excluded. But like I say, the horse is sort of out of the barn. It's kind of tough to get them back into the barn. The judge has already heard that information. I think they can't expressly rely on the witness's testimony, but it's going to certainly, I think, in most cases, color their judgment. How about the Bryant case? In this case, it was held that before a witness's testimony is excluded, the employer must have the opportunity to justify any late disclosure. I think this is just stating the obvious. But don't say the dog ate my homework. We've got to come up with something more sophisticated than that. What about if the applicant's witness, or the defense witness, or any witness for that matter, is unable to testify at trial? They can't make it down to the board for some reason. And let's say you want to avoid having your witness testify or cross-examine down in front of a judge, so instead you'd rather enter the witness statement into evidence. Good luck with that. This is a very, very tough putt. We've got a case. It's going to be up to the judge, but in this situation, they're probably going to argue that this is hearsay, and they don't want to allow hearsay. Now, hearsay is regularly allowed in the WCAD. It's rarely allowed in civil court or criminal court, but in the workers' compensation venue, it is often allowed. But I don't think it's going to be allowed in this situation where we could have had a witness down at the board, but we're trying to rely on the statement. By the way, what is hearsay? I often hear people saying, well, that's hearsay, but the definition they're providing is wrong. Hearsay is an out-of-court statement offered to prove the truth of that statement. An out-of-court statement offered to prove the truth of that statement. That's one of the very few things I remember from 30 years ago at UCLA Law School. The Gates case is applicable here. In this case, the defense offered the witness statement in place or in lieu of live testimony. It was explained to the judge that, well, we want the defense witness, the employee's supervisor, to testify, but he can't because of surgery. Well, that was very simple. The judge said, well, we'll grant a continuance and you can come for the next trial. And guess what? He couldn't make it to the next trial. So the defense suggested that perhaps the supervisor's deposition or written statement be admitted in place of the live testimony. Can you guess what happened there? Nothing very good for the defense. Why? Well, it was stated by the judge that the employee's right to cross-examine the defense witness would be thwarted. Now that's not really exactly true, because at the deposition they had every single right to cross-examine the defense witness. It was also argued that the employee's due process rights would be violated because the applicant is entitled to observe the witness, both on direct and cross-examination. Well, this too seems a little disingenuous, in as much as this could be provided at the applicant's or at the witness's deposition. That said, I think there was another argument, a better argument, that could have been provided by applicant's counsel and adopted by the judge, and that was simply this: that the judge needs the opportunity to observe the witness while they're testifying, to assess their credibility and level of truthfulness. You simply cannot find that in the written, get that information from a written transcript. So what about if you want to get out of the office? Did you know the appeals board can order that any party have the opportunity to inspect the premises where the injury occurred? This does not happen very often, though. At least applicant's counsel does not request the opportunity to do so. Can you guess why? Well, simply put, they're not paid to do that. They don't make any money as a result. Unless it's a big money case and they think they've got some valuable information that they can obtain from a visit to the premises, They're not going to engage in this money burning. That having been said, they can, if they do find that or do believe it's going to be valuable, they're probably not going to inspect the premises themselves. They're probably going to send an expert who can provide later on testimony as to what they saw and what the problems were on the employer's premises. So who does this apply to? As I suggested, all parties. I think as a defense attorney, I often go down to visit the employer's premises so I can get a picture in my mind's eye of what's going on, where the injury was, and how it took place. But our friends on the other side simply don't have those resources. The Abron case, in this situation, the employee decided that they had the resources and wanted to have that expert, a safety expert, go down to the employer's place of business to inspect the place of injury and inspect the equipment. Apparently, there was a serious willful case as well in this matter. It was held that the injured worker, the employer refused, and the judge said, "Nope, you're not allowed to. In fact, not only are you not allowed to inspect the premises, we're going to restrict your expert's testimony because he failed to inspect the premises." Boy, the judge doubled down, and I think the judge doubled down wrongly. How can you possibly penalize somebody for not doing something when they're refused the right and opportunity to do it by the judge? Well, that's what the WCAB agreed with the judge, much to my surprise. But the Court of Appeals said, no, not at all. Feel free to perform that inspection, applicant's counsel. And the reasons they said was Labor Code Section 5701. I thought I had that there. Nope. 5701 and 3202, which said we're supposed to be liberal about everything and protecting people in the course of their employment. And liberality includes allowing the applicant's attorney or their experts to visit the employer's place of business. It's a matter of due process. All right, we see subpoenas all the time, probably most every week in your place of business. But you know how they actually work. What does it say? The Labor Code says the appeals board shall issue subpoenas for attendance of witnesses and the production of documents and testimony in any part of the state. Emphasize the word state. We'll get back there in a second. So where do you get a subpoena signed by a judge? Real simple. Ask for one. There's nothing else you really need to do. No hoops to jump through, no hurdles to jump over. Who can be subpoenaed to a deposition or hearing? Applicant's witnesses, the applicant, defense witnesses, anybody. With a couple of exceptions, this can be done without a problem. The exceptions are, can you guess it? We're going to talk a little bit more about that. Physicians and the QRRs, or strike that, the voc rehab experts who will be testifying as to why the applicant level of impairment and permanent disability is greater than what the AMA guides and permanent disability rating schedule will provide. In those situations, the Labor Code says that it's preferred to have their deposition taken and the transcript entered into evidence than to have them down at the board and having their and being cross-examined. As I was continuing, non-parties may also be subpoenaed down and to the board or hearing, even if, so long as it's demonstrated or it's proffered into evidence that the testimony will be material. Okay, you're going to trial. You've listed your defense witnesses at the MSC. You want to make sure they attend. Subpoena them. You might say, well, wait a minute. These are defense witnesses. These are our friends. These are our pals. They've agreed that they're going to attend. So they want to testify. We know they're going to be there. Well, we don't know whether they're going to be there. They may get in an accident along the way. They may have a sick child who they have to pick up from the school. Any one of a million things can happen that keep them from coming down to the board on the day of the trial. If they simply fail to show up and you say to the judge, we can't go forward without my witness, the judge may very well look askance and say, tough luck. Now, the judge is also going to say, after saying tough luck, or just before tough luck, did you subpoena them? If you subpoenaed them, then the judge is not going to tell you tough luck. The judge is, in all likelihood, if they're following the law, going to say, okay, we will continue this to another date when the witness can attend. In addition to subpoenaing them, I often send, or actually I always send, a confirmation letter confirming that they know the time and date and place that they're to attend and give testimony, and have them sign that and return that to me in a self-addressed stamped envelope, so I can present that to the judge and say, not only, Your Honor, do I have a subpoena, copy of a subpoena that I served on this witness, but I've also made clear with them that they know when, where, and how to appear. So there's a problem here, clearly, that we need to get straightened out before this matter is submitted to you. What if you got a hostile witness, somebody who's going to testify or wants to testify against your interests? Then definitely be sure to subpoena them. You've got all the more reason to subpoena them above and beyond the reasons you would have for subpoenaing a witness who's on your behalf. Want to get your hands on the records, papers, books, accounts, documents? Issue subpoena ducis tecum, which actually means bringing with you under penalty of punishment. So have you received an SDT? It says that you, as the custodian of records, are to appear for deposition with the requested documents, verify under oath that the documents are as requested by the subpoena. Is that how it really works? Have you ever appeared to a deposition when you've received a subpoena for records as the custodian? Probably not. And if you have, very rarely. That's not how it really works. You don't personally appear. The documents are copied by the subpoena service on site, and the custodian simply signs an affidavit saying, yep, that's it. Those are the records as described in the subpoena. If, however, you are ordered, you'll be provided fees and mileage to attend the copying of the record. What about if somebody is refusing to obey a subpoena? Now with time to order contempt sanctions. Subpoena procedure. The WCAB shall issue subpoenas and the subpoenas ducis tecum upon request within the provisions of the Civil Code. This is one of those times that we actually follow the CCP, and it's enforced by the Workers' Compensation Appeals Board and the WCJs, which is a rarity. As a general rule, the California Code of Civil Procedure is kind of reviewed as a suggestion, a general guideline that doesn't have to be followed by the WCAB. But this is one of those rare situations where it absolutely has to. I mentioned earlier about hearsay, how we have hearsay rules that, according to the Code of Civil Procedure, demand in certain situations that testimony or out-of-court statements offered to prove the truth not be allowed. That's made gray in workers' compensation. Sometimes it can be. They can be allowed. Sometimes the judge will disallow them. Subpoenas and SDTs must use the WCAB's forms. Where do you get those forms? They're all posted on the Department of Industrial Relations website. And of course, you can pick any of them up when you have somebody down at the district office. Copy of an affidavit must be served with the subpoena, showing good cause for the production of a requested material, and specifying exactly the matters or things desired, with a detailed of materiality of the matters. Now, this sounds like it's going to be run several pages long. In fact, it's usually just a paragraph long, saying we need this, that, and the other thing, or actually all of this, that, and the other thing. And the reasons are given with basically verbiage that's used in every subpoena. Any party who subpoenas records must send a copy of the subpoena to all parties of record at the same time that it's served on the party or the person, rather, who is allegedly in possession of the record. Continuing with the California Code of Civil Procedure, the subpoena must be served at least 20 days before the production and must be served in sufficient time to allow the witness, the keeper of the records, to locate and produce those records. If the subpoena requires the appearance of a medical witness before the WCAB, it must be served. They've got to give them at least 10 days to appear. But remember what I just said earlier, you're virtually never going to see this. In over 25 years of trials in the Workers' Compensation Appeals Board, I have seen exactly one doctor come in to testify, and they were not testifying as an expert witness. They were testifying as a percipient witness to get their bill paid. It just doesn't ever happen. Of course, now that I told you it never happens, you're going to see it happen on one of your files next week. There is no subpoena needed if the applicant wants to inspect or copy their own medical records. So here's how it normally works. Copy service serves the subpoena. Copy service takes the machine to record, to get the records at your location, and the facility with the records provides the location, production, and the opportunity to copy the records. Each witness who appears before the WCAB shall receive, if demanded, fees. This is when I'm talking about witnesses, I'm talking about the witness who is the keeper of the records. If they demand it, they should receive fees as dictated by the Code of Civil Procedure, and mileage if they need to move the records or obtain the records from some other place. Same as provided in the Code of Civil Procedure. Who pays these records? Pays for this witness fee and mileage? Well, you can guess it. Whoever requested the records, which seems simple enough, unless ordered by the WCAB. But I've never seen that happen either. Bet you didn't know this. If the injured worker is subpoenaed by the WCAB, something that rarely, if ever, happens, the fees and mileage are paid by the WCAB. I guess we know why it rarely happens. Subpoenaed witnesses are required to pay get a fee for travel to and from and 1 day's attendance. This is normally paid at the time of the service. The check is presented when the subpoena is served, not paid before. But if the reason is, if it's not paid beforehand, they're not required to appear. What happens if the applicant subpoenas a witness to testify? Who pays for that? Not the defense. This is one of these rare times when the defense is not required to open up the wallet. The fee is actually reimbursed as a lien against the applicant's recovery. It's not a medical legal. It is a non-medical litigation expense borne by the applicant. Very nice. This is one of those more unusual situations if you're dealing with public entities, or you've got a intoxication defense or felony rule defense. You may need a peace officer, firefighter, or state employee of some other color to testify as to what they perceived or investigated in the course of their duty. And we need to pay for that. We pay or reimburse the public entity for whom the public employee works the full cost incurred in paying the peace officer, so their daily rate. So who's on the hook for this? The party who issued the subpoena and the party's attorney. And we have to pay $275 to get that officer or firefighter down to the board, tendered the day for each day that they are to attend. If it turns out that the cost of doing so is less than $275, they'll later on refund us the difference. And if it costs more, we'll be charged that difference. Why is this doctor so happy? For the reason that we discussed earlier, they don't go down to the WCAB. Cross-examination by deposition. The WCAB favors cross-examination of medical witnesses by way of deposition. That's why all the depositions and cross-examinations of doctors we see are down at their offices. What's a reasonable cost for a deposition? It's a good question. I bet you and the doctor probably don't agree. What if you fail to serve the subpoena and pay the estimated advance fee, which is normally 2 hours? We normally, the doctor normally says they've prepared for 1 hour, whether it's a voluminous file or there's exactly one medical legal. For some reason, they've always prepared for 1 hour, and with the estimate that the cross-ex is going to take 1 hour. By the way, I've very rarely completed a doctor's deposition in 1 hour because there's just so much to ask, particularly if you're doing your best to render that report unreliable so that the judge has to rely on other medical evidence. So if you fail to serve the subpoena and or you fail to tender in advance the fee for the deposition, you have just waived your right goodbye to examine the doctor. Usually the fee is hand-delivered by the attorney taking the deposition, and if it's applicant counsel taking the deposition, they'll similarly hand-deliver a check at the deposition of the doctor and request reimbursement from the defense as a medical legal expense. And this is, if it is a medical legal expense, the defense will need to pay for that or reimburse applicant's counsel. Now, it may not be a medical legal expense because the doctor may be testifying as a percipient witness. That is somebody who saw, heard, felt, or et cetera, something, and they're testifying as to that. That is, they're not testifying as an expert witness and giving a medical opinion, but we'll talk more about that later. 5811, must the defense reimburse all doctor depositions as medical legal expenses for expert testimony? Maybe, maybe not. Labor Code Section 5811 provides that in all proceedings before the appeals board, costs between the parties may be allowed by the appeals board. So when applicant's counsel says you must pay this, that, or the other thing for a deposition, that's a maybe, because it's may is discretionary. The doctor's deposition is treated much like a medical legal lien is. That the employee shall be reimbursed for medical legal expenses, example, doctor's deposition, that are reasonably, actually, and necessarily incurred. And the reasonableness of this is going to be determined at the time it was incurred. So let's say there was no issue between the defense and applicant when they took the deposition, and therefore proceeding with the deposition is unnecessary. If the defense is stipulated to everything. There are other situations in which this occurs. For example, let's say that the applicant's counsel had received the medical legal, but the defense had not, and it's served on the defense at the doctor's deposition. Clearly, the doctor's deposition at that point was not reasonably or necessarily incurred because the defense has not had an opportunity to review and determine how they're going to respond to the medical legal. For all applicant's counsel knows at that point is that the defense is going to stipulate that everything in the deposition or in the doctor's report. You need another tool to fight being forced to pay the depositions called by the applicant. Question whether the deponent is really an expert, something I was just suggesting a few minutes ago. This is determined on a case-by-case basis. This usually shows up when we're taking a voc rehab or the applicant is taking a voc rehab expert's deposition. And if even if this QRR has testified many times, even in front of the same judge, and has been deemed an expert, that doesn't mean they will be deemed an expert in your particular case. So it's something that you can challenge. Their expertise is something you can challenge, and believe it or not, it is sometimes very easy to challenge that, particularly when they've demonstrated through their report that they don't know the actual rules involving this this task. So what about if you've been served a subpoena and you don't want to respond? File a motion to quash. Simply don't want to comply and don't want to file a motion to quash? What could possibly go wrong? Well, let me introduce you to sanctions. Duh. With the WCAB, this is interesting. You may never have heard this. You refuse to file a motion to quash. In addition to getting sanctioned, the WCAB can report you to the Superior Court for the failure and request an order compelling to obey from the Superior Court. And the Superior Court can then direct the applicant or the witness to appear at a time and place and show cause for earlier failure to comply. And of course, if good cause is not shown, sanctions are going to come. Still failing, here comes the contempt motion. Now, love this picture. Now, you've never done it that way. They've never gone through Superior Court because of these procedures. There's a great reason that you haven't gone to Superior Court. The WCAB can do exactly the same thing. WCAB has the power to issue orders regarding subpoenas and punish by way of contempt for failure to comply with a subpoena. So this is how it's really done. The subpoena issues, the subpoena is ignored, the party petitions the WCAB for an order enforcing the subpoena, and the same party serves that order. If the order is ignored, the subpoenaing party requests contempt proceeding. Now, in situations involving doctors, for example, there may be plenty of blame to go around. A doctor can be held in contempt for failure to respond, for example, as can the attorney instructing the doctor to refuse to follow the valid subpoena. And this has happened. Both of them can be held in contempt. Who uses paper anymore? Well, we're in a paperless society, although sometimes that seems to create more paper. If the records are recorded or reproduced via microfilm or electronic recording, and the originals have been destroyed, we shall use a legible printed up or film or electronic recording, which corresponds or responds to the subpoena. What about offering into evidence legible print, film, electronic recording? Despite the provision in the code that says we can use film or we can use electronic recording, we can avoid cutting down any more trees, the judge can say, hey, I'm old school and I'm going to require paper reproductions. This happens more often than probably should, and more often than is justified. What about x-rays? There's actually statutes directly on x-rays. You need the original. Well, the party can get an order and have these subpoenaed when they are relevant. X-rays produced in violation of that need to be returned in the original custody, custodian at the expense of the party, causing them to be produced. But why would we have x-rays subpoenaed? Well, to have our own physician analyze the original. Interestingly, the statute deals with x-rays. There's nothing about MRIs. There's nothing about CT scans. There's nothing about any other diagnostic products. CCR 10322. This basically says don't take the records of the WCAB from the WCAB. They got to stay there. You're going to get in big trouble if you take them out. You need them, or some portion of them, then you subpoena them and pay for it, the copies and the subpoena. That having been said, if you do it the correct way, you'll receive a certified copy, and that's what you're going to need to get the records into evidence anyway. What about if the witness that you want to subpoena, whose deposition you want to take, or you want to get them down to trial in front of the judge to cross-examine them? What if they've left the state of California? Now you've got a big problem. The witnesses are not obliged to attend as a witness unless they are a resident within the state at the time of the service of the subpoena. So if you subpoena them now and they leave next week, you can still they can still get in trouble. Now, interestingly, because this jurisdictional rule is explicitly limits the WCAB from extending its power out of state, the witness doesn't even have to object to such a subpoena. It's just void on its face, meaning the judge just takes one look at the subpoena and says, "Nope, you don't. I don't have the authority to order this witness. If they are outside of my jurisdiction, they get to stay away if they want to stay away." What about the U.S. Constitution? Is that actually part of workers' compensation? Well, as a matter of fact, it is. Not very often. What's the hierarchy? First, we start at the WCJ decision level, then file a petition for key consideration to have the WCAB in San Francisco take a look at the matter. They can either issue a panel decision or a en banc decision. Then next step up is the District Court of Appeal. The next step is the California Supreme Court. And the next step up is the U.S. Supreme Court. And it really does happen. Take a look at this 2018 Shemet versus Perry. The employee the employee at the trial pled the fifth. The employer claimed a denial of due process. The judge found, nevertheless, even though the applicant failed to testify or refused to testify, saying, "I invoke the Fifth Amendment. I don't want to get myself in trouble." The judge said, "Well, we don't need your testimony anyway. It's okay. We're going to find AOE COE based on the QME report." And the employer said, "Well, wait a minute. We've been denied due process. If we can't cross-examine the applicant and get information that, for example, the QME might need, how can we claim that we've had the opportunity to defend our interests?" The holding was no. Defense, you have not been denied due process. And it was because the defense did a lousy job, I think. They failed to exercise diligence and exercise in its rights. They didn't make an offer of proof as to what questions it sought to ask, which is something that needs to be done at the deposition. Applicant is asked XYZ. His attorney says, "I'm instructing you not to answer. We are invoking the Fifth Amendment." And then the person taking the deposition needs to put on the transcript, "I'm asking thus and such, I'm asking thus and such, and thus and such. Is it stipulated by applicant's counsel that you're invoking the Fifth for all of these questions?" Yes, it is. That you need a record made. Also, in terms of failing to exercise its due diligence, it was noted by the court that the defense didn't claim it was prevented from cross-examining the applicant during the deposition regarding allegedly illegal activities. It was simply at the trial time. They didn't offer the employee's deposition into evidence at the trial, nor have they attempted to have them introduced once the employee invoked the Fifth. So the defense just completely fell down on the job here. Does this mean does Shemet mean employers can't successfully claim a denial of due process when the Fifth is invoked? Probably not. Like I say, the employer did a terrible job. Do you have a right to cross-examine all adverse witnesses? Yep, you betcha. The judge can even compel a doctor to appear, participate as is necessary. But don't blow it. You may have a right to depose, but you're not always entitled to do so because the entitlement can be waived. Example, if you fail to cross-examine the doctor prior to the hearing. Now, believe it or not, the applicant doesn't have an absolute right to attend a doctor deposition. Occasionally, we'll run across an applicant or applicant's attorney who wants the applicant to attend the deposition to keep the doctor on the straight and narrow. But there have been situations, in a psych case in particular, where it was instructed that the applicant not appear. The reason was the applicant was deemed to be dangerous. If they thought if they heard the doctor's testimony, there would be potential harm to themselves, to the doctor, and the defense attorney. So at this situation, we say, you know what, applicant's counsel can more than adequately represent the applicant at the doctor's deposition, and we're going to proceed in that way. Refusal to allow a doctor deposition is very rare, and very rarely do doctors object to having their deposition taken. There is one study or group of doctors, however, who will not have their deposition taken, and that's the consult. We can take the deposition of the PTP, we can take the deposition of the QME, we can take the deposition of the AME, but we do not have the right to take and cross-examine the consult that is utilized by the PTP, QME, and or AME. And this is not considered a denial of our due process. This leads to a problem. One in particular that jumps out at me, Labor Code Section 4663, which is the apportionment standard. Its apportionment is where the doctors provide the quote-unquote approximate percentage of permanent disability, AOE, COE, and the quote-unquote approximate percentage of permanent disability that's non-AOE, COE. In other words, the doctors provide the apportionment, and we all remember the Benson case, where we are allowed to split up permanent disability per injury unless the doctor says it's inextricably interlinked and they can't make the apportionment determination. Well, Labor Code Section 4663 says that the doctor says they can't make the apportionment determination, then the physician, quotes, shall consult with other physicians. They need to talk to somebody who's smarter than they are. Well, if we want to get information about that consult, we have to rely simply on the PTP, QME, or AME's word. By the way, just a thought about that. I'm sure you've all faced a situation where you think you have a Benson defense, but the doctor has used the magic words inextricably interlinked or verbiage to that effect and refuses to split up and just simply says, I can't apportion. At that point, I strongly recommend you file a petition for the assignment of a quote-unquote regular doctor to act as a consult. A regular doctor, well, you all remember an independent medical examiner, that verbiage is no longer used in the labor code. It's been replaced by quote-unquote regular doctor. So if the doctor, either the AME, QME, PTP, refuses or claims they can't provide an apportionment determination, you petition the WCIB for an order for the assignment of a consult between that medical legal physician and another smarter doctor. I've done this several times in Southern and Northern California. In each case, applicant's counsel has blinked and we've been able to come up with a reasonable settlement. Doctor deposition fee, well, we're going to get to that next time we come together. We are done for the day.